Hi, this is Steve Rothman from Rothman and Company, and this is one in a series of videos that I've been doing pertaining to startup companies, and especially startup companies that grow out of universities and research institutes. In most of the videos I've done so far, the focus has been primarily on the founder and the company. Today is going to be a little different. I'm going to focus on the investor and some things that might be of particular concern to them. So we're talking about a company that comes out of a university or research institute, and I'm distinguishing that from a startup in which the founding team conceives the business plan and invents related technology in their garage or elsewhere, but not as employees of another organization. In the university startup, the inventor is typically a professor, a postdoctoral fellow, or a graduate student, and the base intellectual property on which the company is going to be formed is typically owned by the university or research institute, not by an individual founder or a group of founders. So that's different from a situation where the founders would be contributing the IP to the company, which is what you would expect outside the university context. So first, I'd like to talk about some distinctive features of university startups. Often you have cutting-edge technology. Anecdotally, university startups have a higher success rate than others. I haven't seen any hard data on that. There may be some, I'm not sure. A lot of people say 9 out of 10 startups fail. It's somewhat better than that in the university setting, but it's hard to get data. But if you think about it in terms of the key risk areas for any startup, what do you need? You need technology, you need management, you need market demand, and good timing, a few other things probably. The university startup, or one from a research institute, at least usually has the technology angle covered. They may or may not have the other things, but they have published technical pieces in peer-reviewed journals and have had assistance with patent protection from their institution, so they probably have some good technology and some good IP. So very generally speaking, the technology risk is lower, but there are more issues around assembling management. Often the technology, though interesting, is very early stage, and therefore even more than other startups, the timeline to profitability may be longer and more uncertain. So if you're familiar with startup investing, but not with university startup investing or investing in a startup that comes out of a research institute, some things are going to be unfamiliar to you. First is that the IP is owned by the university and it's going to be licensed by the company rather than contributed to the company, at least in the United States. In Europe, that's not necessarily the case. The Federal Bayh-Dole Act, which was passed in 1980, I'm going to talk about from time to time because it influences this type of company. It's going to apply to intellectual property if there was government funding in the invention. And it has some quirks which mostly turn out not to be problems, but take getting used to if you haven't seen them before. So I'm going to discuss them later, but they're things like the preference for US manufacturing and something called march-in rights. Next feature that is different in a university startup is that they primarily rely on patents for protection of their intellectual property rather than trade secret protection, at least for the original IP that comes out of the institution. And that's because trade secret isn't available when the technology is being published, and usually, in a university setting, the whole point of them doing their work is to publish it, so they're not going to be able to keep it as a trade secret realistically, and therefore you're going to have a patent, whereas in another context, you might make the decision between patent protection and trade secret protection, and they each have their advantages and disadvantages, which I won't go into here because it would take a while, but you're gonna be relying on patents. One disadvantage of patents is that there's patent application expense, which is still ultimately done country by country, although that is mitigated to some extent by some treaties that let you defer costs. You still have to go into each country eventually where you want to have protection, which hopefully is something that would change someday, but that's the way it is now, so it's quite expensive to get patents. Next feature that would differentiate this type of investment from some other one is that usually the lead inventor is not going to join the company. They're usually going to remain at the university as a faculty member or at the institute as a researcher. Those are good jobs, very secure jobs, jobs that offer a lot of freedom and a lot of security, and it's not that common for someone to want to give that up and be an entrepreneur with a startup that may or may not make it. It'll happen sometimes, but not that often. Next feature that differentiates this type of investment is that initially there are no assets other than the university license. So there's no security. If you're doing a financing with convertible notes, which I don't favor anyway, but if you are doing one, it doesn't make any sense to talk about securing the notes because there's nothing to secure them with, whereas in a startup that the founders were the inventors, you could secure using the IP. So that's my general overview of the distinctive features of this type of an investment, and I'd like to move on to talk in a little more detail about various topics. First, the management issues. So one issue that comes up is, should the professor who was the inventor be the CEO? As I said, it doesn't come up that often because they're usually not interested in leaving and working full-time at a company, but it does happen sometime. You see them take a leave of absence for a year or two and see whether the company gets going or not, and typically the university will allow that. What are the issues with having a former professor as your CEO? Generally, they're not familiar with market or customer-driven approach to work because that's not their training, right? Their training has always been that they have a lot of freedom in what they work on and that they want to work at the cutting edge based on what's happening around the world in their area of science, and that's not what you do when you're with a company. You work on the problem that you need to work on in order to get the product to the market. So that may pose a problem. It may not for others. It depends on whether they can make that transition. Often, if the professor's going to remain at the university, another situation that you see is that a postdoc or grad student who was in that professor's lab becomes the CEO. And that way they get a job and they know the technology very well. They're enthusiastic and they're inexpensive compared to hiring more seasoned people, but they're generally lacking in business experience, and so that's the drawback, and sometimes you'll see them do it on a temporary basis. Another alternative would be an entrepreneur in residence from a venture capital firm might come in as CEO, and then the main issue will be how they get along with the inventor and other technical members of the team. The best solution when you can find it is probably an industry veteran as CEO. If you can find and motivate the right person, that's the way to go, but those people don't grow on trees and they're somewhat expensive, and startups usually pay low salaries, etc. So you're not always that lucky. Moving on from the management issues, I'd like to say some more about the intellectual property situation in startups from universities or research institutes. So here's the IP framework. As I said, you're going to be relying on patents, not trade secrets. There's a lot of time that's wasted fighting over this in connection with negotiating the university license if the people involved, the lawyers and others involved, are not familiar with the university culture, because they're going to argue that they want the professor to agree that they won't publish any of their work in this field going forward, and they're not going to agree to that. They just won't agree not to publish university inventions. Sometimes you'll see a limited delay in publication, which is intended to allow the company to assess a new invention and decide whether it's patentable and worth trying to patent, and then get their patent application on file before the publication. And the other purpose of the limited delay is that the company can review the manuscript to assure itself that there isn't any company confidential information in the publication. So delay is okay, but it's typically not very long, 60 days, something like that. Of course, for inventions that come out of the company itself, once it has hired a staff and has some scientists presumably doing research, the company, that's like any other company, right? So they can use trade secret rather than patent if they want for their own internally developed inventions. And copyright is also a possibility, whether the invention was at the university or at the company. You'll sometimes see reliance on copyright. The Bayh-Dole Act generally prohibits, in the case of nonprofit organizations, which universities are, assignment of rights to an invention made with federal funds without the approval of the funding agency. So usually you don't see assignment of the IP into the company. Instead, the original IP on which the company is based is going to be licensed from the university or research institute to the company. So there will be a license negotiation, and there may already have been a license put in place before you come around as investor, and then often there's a renegotiation, but there will be a license. And I'm not going to go into details. That would be a whole other talk in terms of what comes up in the licensing, but briefly, there would typically be a royalty. Often a modest equity stake would be retained by the university or research institute, and other negotiated terms. It might include an issuance fee for granting the license, milestone payments, sub-licensing fees. The licenses pretty much always include patent prosecution reimbursement to the university or research institute. And sometimes, at least in the first draft, they have some kind of assignment restriction or a fee for assigning the patent, and that's something that investors will typically try to negotiate away or to turn into a very low amount so that it's not a concern, because otherwise there's a possibility of it having an impact on an exit. The fact that the IP has to be licensed rather than assigned generally comes as a surprise to European investors or European corporations if you're dealing with a situation where there's a corporate sponsor for the startup. And it comes as a surprise to some American investors if they haven't dealt with university startups before. Going forward, as I said, the IP invented at the company will of course belong to the company, but if the university or research institute personnel have some ongoing role, then the ownership of the IP, if it's invented with material use of university resources, will be owned by the university or possibly co-owned if there was also company participation. And then it'll generally get added to the license. Now, so this raises a couple things. First, what's material use of university resources? It's pretty much generally conceded by universities that if a professor uses his office telephone to answer calls from the company, that's not material use of university resources, and neither is just regular use of the library. But lab experimentation, that's different, right? And that's not the only thing that could trigger a claim from the university to some ownership interest. And the second issue is whether there's going to be a payment for a new invention that comes out of the lab of the professor who started the company. Those improvements won't automatically be included in the license. Some universities will throw in improvements from the same lab for a very limited period of time, or for a limited period of time, 3 years, something like that. Others expect some payment invention by invention, but the payment is usually small if the new developments would infringe the original patent, because there's only one customer for the technology, which is the company that has the base patent. Sometimes this startup will sponsor, meaning pay for, research at the university, which can make sense if the university has needed equipment or personnel that they don't want to reproduce at the company. It can save money, but then you have the issue of the university having a claim to the IP and it having to be added to the license. When there is sponsored research, U.S. tax rules that are applicable to nonprofits prohibit fixing the terms of the license at the time of the sponsored research agreement, because the license is supposed to be on fair market terms, as if the licensee, the company, hadn't been the sponsor. And you can't determine the fair market terms when you don't know what the invention is yet. So the license terms have to be set later, which again is something that the licensee tends not to like, because they're putting their money in. They're paying twice, in a sense. They're funding the research, and then they're also having to have a negotiation over the license. Sometimes some people think that it's okay to have a royalty range, so not a specific royalty, but a royalty range stated in the sponsored research agreement. So there's a balance between the desire for the startup to own the IP outright, which would push you toward having all future work done at the company and exclusively at the company, versus having access to university talent and equipment, and that's something you're gonna decide case by case. In addition to the license, I just want to mention quickly that there's usually, assuming the faculty person doesn't join the company, there's usually going to be a consulting agreement with the faculty inventor. And those agreements have special requirements. You can't just use any old consulting agreement because they have to fit within pre-existing university rules, such as the fact that there is that professor is already under an obligation to assign his inventions to the university. So you can get into problems with inconsistent assignments, and that's what happened in the Stanford versus Roach case that went to the Supreme Court a little while ago. So you want to be sensitive in the consulting agreement to the university policies and try to anticipate and avoid problems. So that's the overall IP framework. Now I want to come back. I had mentioned at the beginning, or close to the beginning, that there are a couple of features of the Bayh-Dole Act that typically initially concern investors who haven't encountered them before, although ultimately, typically, the investors get comfortable with them. The first is what's called march-in rights. And under the Bayh-Dole Act, theoretically, the U.S. government can force the company to grant a sub-license to the intellectual property that it has licensed from the university, and if they don't, the government can itself grant a sub-license to another party if the patent holder is not commercializing the technology. There are certain bases for this, for the march-in rights to come into play. It would be the company not commercializing the technology if it's necessary to alleviate health or safety needs that are not reasonably satisfied by the patent holder, and in this case by the startup company, or if the company otherwise isn't complying with certain requirements of the Bayh-Dole Act. So this sounds scary to investors who always expect exclusive rights, and the idea of the government being able to make you grant rights to someone else is not pleasing to an investor. But the thing to keep in mind is that the march-in rights have never, literally never, been exercised. I think the law was passed in 1980 and we're in 2013. It's been 33 years. There have been a number of cases where people have petitioned the government to exercise march-in rights, and it never happens. And if you read the cases, the facts and the analysis in the cases where agencies have been petitioned to exercise march-in rights and have declined to do so, you'll find that they set a very strong precedent for not exercising march-in rights. Essentially, they would never be exercised except in highly exceptional circumstances that generally aren't going to be a concern. If you want more detail on this, you can look at the NIH 1997 decision regarding CellPro, the 1999 NIH letter to Ralph Nader, the 2004 Abbott Labs Norvir case, 2004 Pfizer Salatin decision, and the 2010 letter regarding Fabrazyme. So that's it for march-in rights. Don't worry about them. The next item that's part of the Bayh-Dole Act that investors don't love is that it states a preference for U.S. manufacturing where there is an exclusive license, and typically companies want exclusive licenses, not non-exclusive licenses. But again, there are a lot of exceptions and limitations to this. First, the statute requires manufacturers substantially in the United States. Now, substantially is kind of vague, but for example, in electronic products, you might have parts like circuit boards made abroad, but then brought to the U.S. for final assembly, software installation, and quality control. And arguably, that might be substantial manufacture in the U.S. So it doesn't mean no manufacturer can occur abroad. It just has to be substantial in the U.S. Secondly, you can get the whole thing waived if domestic manufacture is not commercially feasible, or if the university had tried unsuccessfully to find a licensee that was likely to manufacture in the U.S. And the NIH in particular has a reputation for a streamlined waiver process and a willingness to grant waivers fairly freely, particularly if there is reason to believe that foreign manufacturing will allow a medical product to be made available to patients at a lower cost. If you are going to apply for a waiver of the U.S. manufacturing requirement, you should address the following points. Whether anyone in the industry manufactures in the U.S., because often it's the case that no one does, and then it's usually pretty much a slam dunk that you can get a waiver. Where are competing products produced? What are the relative costs of U.S. versus foreign manufacture of the product in question? Will at least some manufacturing be done in the U.S. even if it doesn't qualify as substantial? Are there other benefits to the U.S. economy, such as additional jobs in the U.S., not in manufacturing, but in research and development, or design, or sales and marketing? And are there taxes to be paid by the licensee for sales in the U.S., etc.? Other considerations regarding the U.S. manufacturing preference are, one, it only applies, as I said, to exclusive licenses, not to non-exclusive licenses. So if in a particular case you're getting a non-exclusive license, it's a non-issue. And secondly, if you don't meet it, that doesn't invalidate the license or the exclusivity of the license if the government agency that funded the work isn't taking any action. So there was a case, Ciba-Geigy versus Alza Corp. In 1992, where it was argued that, hey, they're not manufacturing substantially in the US, therefore their exclusive license to the patent is invalid, therefore other company, can go ahead and make the product. And the court ruled no. Failure to meet the requirement doesn't affect the IP rights or give a third party a right to invalidate the exclusivity of the license. That would require the government agency to come in and take some action, and in that case the government agency hadn't shown any inclination to do so. Another thing about the Bayh-Dole Act is that by statute the inventor gets a share of the royalties that are paid to the university. The amount of the inventor's share is not set by law. It typically is set by the policies of the university or research institute in question, and it varies from one institution to the next. That can cause some issues. You may not want the professor negotiating the royalty, but usually his or her interest is more aligned with the company than with their share of the royalties, but still it's something to keep in the back of your mind. Some distinctions to keep also in mind are whether we're dealing with a U.S. university versus a non-U.S. university. As I said, the U.S. universities usually won't assign intellectual property as opposed to license it, and they're subject to the Bayh-Dole Act rules that I've been talking about, whereas universities from abroad, my understanding is that in Europe, typically universities will assign IP. And then another distinction to keep in mind if you're dealing with U.S. universities is whether it's a public or a private university. The public universities are obviously operating with state funds, and they have a higher level of scrutiny and potential political issues and applicable laws that constrain their flexibility more than private universities. So at times it's easier to deal with the private universities, but there are some great public universities with great IP, and so they're still in the game. Some of the pitfalls that are particularly associated with startups that come out of universities or out of research institutes. The first would probably be the lack of a complete management team. As I said, usually the faculty inventor will remain on the university faculty, will devote no more than 20% of his or her time to the business. So you need some other person or group who's going to be dedicated to the business, someone who knows the market and has good business judgment. So that's kind of issue number one. Issue number two is failure to recognize the early stage of the technology. Early stage investments can be rewarding, but you need to have the patience and the capital and to take it into account in the valuation. And typically, university inventions, they're early stage. They're not ready for the market, and they're not going to be ready for the market without quite a bit more work. The upsides of this type of investment in companies coming out of universities and research institutes, you have a lot of exciting new technologies. You usually have patent protection, which gives you a good, blocking IP position. You get to piggyback on government funding. Typically, there's been a ton of government money that's been put into the basic research that underlies the invention. And you have a talent pool from the university. Often, the startup company is going to draw for its research scientists, people out of the lab that did the original work. So, my summary and conclusion is that university technology offers investors a chance to participate in inventions that may change the world, often having a head start from extensive government funding in basic research. Investors who are contemplating that type of investment should understand certain special issues applicable to university startups that are different from those encountered with other startup enterprises, including the Bayh-Dole Act restrictions that I've discussed, reliance on patents rather than trade secrets, the likely early stage of the technology, and whether there is an adequate management team in place. In light of the benefit of obtaining cutting-edge university technology, though, on balance, university spin-out companies can offer compelling opportunities to investors who have the time, patience, and money to locate and nurture the most promising of them. This has been Steve Rothman of Rothman & Company on September 5, 2013. Thanks for listening.